না একটু মেনশনিং আছে। But I'm seeking a lordship's leave to mention. But I'm seeking a lordship's leave. But on Monday, we were on legs before court number 3 and 4. My lord, and a bail application was dismissed by your lordship.
Yes.
But we have filed a restoration.
Yes, what is the correction?
Yes, ma'am.
Name of the state lawyer wrong with
Item 1.
কি হবে?
instead of Bhattacharya and instead of Chatterjee, Chakraborty.
Item 1 is AP.
Mrinal Paul,
Yes. Item 1 is my matter.
your matter.
Yes. Now the correction required is at para 7. Page 3, my lord. Para 7, the first line itself, by a lawyer's notice dated such and such, Utpal,
Yes,
this will be Mrinal, the petition.
of course.
Yes.
Yes. Let the judgment and order dated April 4, 2025 be corrected by substituting Mrinal, comma, in the place instead of our Utpal inverted comma, in the first line of paragraph 7 of the judgment and order. So let this correction be incorporated in the judgment and order.
Yesterday, my name reflected in the order sheet.
Mr. Kollul Nag also appeared?
Yes.
I see. 8. Let the order dated April 4, 2025 be corrected by including the name of Mr. Kollul Acharji, comma, advocate, in the cause title of the order as having appeared as counsel for the state. Let this correction be incorporated.
Good.
The order sheet, our name has been changed by both the state lawyers. Instead of Chatterjee, Aditi Shankar Chakraborty is to be written.
Yes.
And instead of Bhattacharya, Tapan Bhattacharya is to be written.
Acha. Oh, Mr. Chakraborty has been totally changed.
Totally changed.
Yours is only the spelling.
Yes.
That is pardonable. কি করেছো তুমি না এটাকে কোলে
Mr. Kohli.
Let the order dated April 7, 2025 be corrected by correcting the names of learned counsel for the state as Mr. Aditi Shankar Chakraborty and Mr. Tapan Bhattacharya in the place instead of Mr. Aditi Shankar Chatterjee and Mr. Tapan Bhattacharya, respectively. Okay, let this correction be incorporated.
Okay.
লিখে দিয়েছেন উনি।
I'm for the petition, Lordship. Lordship, I am for the refractory complaint. So the FIR was registered initially under section 363, 364A, 348, 384, 386, 379, 34 of Indian Penal Code against 5 accused persons. So on the backdrop of demand of money, the allegation was leveled against the petitioners and other accused persons that the de facto complainant was restrained illegally and demanded rupees 10 lakhs, and his ATM was taken away and he was assaulted. However, Lordship, charge sheet has been recently been submitted, Lordship, where there is no injury report, no seizure.
Recovered.
No, nothing, Lordship.
The victim,
The victim was all along because he was not kidnapped at all. Lordship, the fact is that, Lordship, and the charge sheet has been submitted, Lordship, there is no recovery of any sort or any debit card, any debit amount of anything else, nothing. Lordship, however, the three accused person has been released on anticipated by this honorable court. The rest two are before your Lordship. Meanwhile, the de facto complainant has settled the issue between the parties. He is appearing through.
Yes, your Lordship.
settled.
Yes, your Lordship.
ও তাহলে তো হয়েই গেল আর কি। We'll record your objection.
Don't you pass decided corroborating with the prosecution case?
161?
One, corroborating with the prosecution.
Very good. Issue. The petitioners say that the other three accused persons have been granted anticipatory bail by this court.
Why this one?
By this court. By the High Court court. This court, whatever I'm here. By the High Court. Stop. They stand on the same footing as those three persons. Stop. The matter has been settled between the accused persons and the de facto complainant oblique victim. Stop. No money or any other incriminating material was recovered from the accused persons. Stop. The victim did not suffer any injury. Stop. He was not abducted, in fact. Stop. Paragraph. Learned advocate appears for the de facto complainant oblique victim and supports the submission made on behalf of the petitioners. Paragraph. Learned state counsel, while opposing the prayer for anticipatory bail, in her usual fairness, leaves the matter to the discretion of the court. Paragraph. In view of what I have recorded above, I see no reason to deny the prayer for anticipatory bail accordingly.
Great.
Five,
My lord, item number 5, I appear on behalf of the petitioner, my lord.
My lord, I am for the state in this matter. May I not?
Yes.
My lord, on last occasion, my lord was pleased to direct the inquiry officer to be present before your lordship and
Yes.
explain his conduct. My lord, he is present here and he has submitted a report, my lord.
Yes.
From the report, it appears that he tried his best to obtain the report, but
That's all right, Mr. Vishwas. Then let me direct the director of the concerned laboratory.
my lord. And my lord, charge sheet has already been submitted. I have spoken to him whether if the custodial interrogation of the accused is necessary at this stage or not. He said no. Since we have concluded the investigation, the custodial interrogation is not required. Right?
Then
Arrest
let-
করার দরকার নেই তো আপনার এখন ইনভেস্টিগেশনের জন্য।
can we record that?
My lord, his statement.
A issue. Pursuant to my order dated April 7, 2025, the investigating officer of the case is personally present in court. Stop. He files a report. Stop. Let the report be kept with the records. Stop. It appears from the report that in spite of his best efforts, the chemical report could not be obtained. Stop. Till date, could not be obtained till date. Stop. Paragraph. What is the charge?
So the Excise Act, my lord.
Oh,
4AC and 52 of Bengal Excise Act. my lord.
the charge is under sections 4 bracket capital A bracket capital C oblique 52 of the Bengal Excise Act. Stop. Paragraph, I have considered the facts and circumstances of the case. Stop. The investigating officer who is present in court instructs his learned counsel that investigation is complete and charge sheet has been submitted.
POR, my lord, prosecution officer.
Oh, Ayuna, PO.
No, these are complaint cases, my lord.
Oh, investigator as a prosecution officer. Then appearance also prosecution officer.
No, he is an inquiry officer. Inquiry officer. my
Who
lord.
is he?
He is the inquiry officer of this matter, my lord.
Not
These are,
investigating.
no, in excise and forest matter, the IO is EO.
তাহলে আগেরটা ঠিক আছে, এখানে এনকোয়ারি অফিসার বলো, পার্সুয়েন্ট টু আর্লিয়ার অর্ডার, ওটা যেটা অ্যাপিয়ার করলো ওটা এনকোয়ারি অফিসার।
হ্যাঁ।
And এখানে prosecuting officer has instructed the learned counsel for the state that investigation is complete and charge sheet has been submitted.
POR. POR. The conclusion of the investigation, the report is called POR in CR cases. my
Oh,
lord.
POR, and
Charge sheet is filed by the police and CBI.
very well. PO, what is the full form of POR?
Prosecution office. report, right? Prosecution office.
Offense, prosecution offense report, bracketed charge sheet, the বড় term সব।
POR. Short form is POR.
For our understanding, has been submitted. Stop. Immediate, there is no need to interrogate the petitioner in custody at this point of time.
Well,
Paragraph, in view of the above, I allow the petitioner's prayer for anticipatory bail.
My lord.
Numped.
Lordship, I'm praying for a short Passover. The de facto complainant is coming from Malbazar, Lordship. Pray for it.
I'm going to state your law.
With whom did you fight?
Three 31631 420 406 465, not 467 and 471, all below 7 years. I was served on 35 3, which is actually 41 and complaint. But in 1947, my grandfather, being the owner of the land, gave a lease to Mr. X. Then Mr. X was owning a cinema. He continued to operate a cinema hall in that area. I had a homestead over there. I continued to operate the homestead. But in 1960, state acquisition act came in 1953. 1964, my grandfather possibly contested the fact whether this land is mine or not, but I believe it was non-prosecuted. Thereafter, we had no idea what was going on. The matter, I continued to live, my whole family continued to live, and the cinema hall also continued to operate. In 2020, we come to see that the cinema hall has been broken and portions of my other portions of land are being taken. So we filed a civil suit. The injunction is refused, saying that we can't show properly appropriate document. Now, once we lost the injunction, we went before the High Court. The High Court said, yes, you are making out a prima facie case, and the fact that you have a homestead and State Acquisition Act might not be applicable so far as you are concerned, because you already have a homestead and you've not been adequately compensated. Hence, the High Court sends it back to the lower court. The lower court again refuses, saying that no, we are not in a position to decide on it. We will decide on it. It again comes back to the High Court. An interim order is granted by the division bench, headed by Justice Jalpaiguri. Justice Jalpaiguri indicates that yes, you are making out a prima facie case. There would be an order of injunction, and nobody else can transfer the property till the time this list is being decided. But the final order, which is passed by Justice Standard, he says that subject to suit, subject to the outcome of the suit, the process of the lower court would be bound by the subject to the outcome of the suit. This order is challenged in Supreme Court. Supreme Court says no, unnecessarily the division bench initially, which the division bench gave an order, but subsequently it modified. This modification is creating trouble. The person who has taken up, basically the cinema hall owner, who's building a property over there, is going to get third-party rights. That is estopped. The moment that is there, the cinema hall owner goes and files a criminal case against me, saying that in 2006, my PC has sold the property.
Lordships.
This is the issue.
Charge sheet?
Not filed, your lordships.
Yes, but then this is really a civil dispute. Investigate, he will fully cooperate.
It's pending in Supreme Court.
He's fully cooperate. Issue. The petitioner says that the
Lordship 41 compliant.
41 is, He's cooperating with you. Petitioner says that the dispute between him and the de facto complainant is purely of a civil nature. Stop. Various civil litigations are pending in various courts at various levels. Stop. He is cooperating with the police in the investigation. Stop. He has responded to the notice under section 35 BNSS.
Cost 3, Lordship.
35(3) BNSS bracketed is the 41A CRPC. Section 41 in CRPC. Bracket closed. Stop. His custodial interrogation is unnecessary. Paragraph. Learned state advocate fairly submits that the petitioner has responded to the notice under section 35 bracket 3 BNSS and that he is cooperating with the investigating authority. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case, I am of the prima facie view that the dispute between the parties is primarily civil in nature. Stop. Noticing the fact that the petitioner is cooperating with the police, I am of the opinion that immediate custodial interrogation of the petitioner is unnecessary.
But she only indigenous as and when Paul Ford may cooperate.
Yes, so all conditions are there.
Only the counter jurisdiction without to go to Supreme Court to follow up. That's all. Your Lordship does not give a specific.
Jurisdiction থাকে না তো anti-bail এ?
So long as your Lordship.
For 438(2), not to leave India.
My lord, the report was called for whether the documents which they have given, Indian documents, those have been verified, those are all genuine.
Genuine.
This is the report.
Fourteen C is harboring. Harboring. For harboring maximum is? And for 14A, what is the maximum? 5 years. A report has been filed by the SI Sunil Guru of New Jalpaiguri PS in terms of my order dated April 3, 2025, paragraph. It appears, let the report be kept with the records. Let the report be kept with the records. Paragraph. It appears from the report that the documents submitted by the petitioner in support of his case that he is an Indian national are authentic documents. Stop. This would show that indeed the petitioner is an Indian national. Paragraph. In view of the aforesaid, I am of the opinion that immediate custodial interrogation of the petitioner is not necessary.
Grateful.
Charge sheet pending.
Pending, Lordship, pending, Lordship.
Not necessarily, so long as he cooperates with the investigating officer.
It will not be. 9. I am for the state Lordship.
De facto is a lawyer.
Personally present, Milord. He met with the.
I know, I said to
He may be represented by.
ask her if some lawyer has been engaged on her behalf. Why? Very bad case. On the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed before the next available circuit bench.
11.
Pass over? Not today.
Well,
Well,
Mr. Ganguly is there.
He's busy in code number 2. You can hear him on his
anyway, it won't be heard again. Chalo, next Dakota. Let it be passed over. If you are not there, then
Ati,
13 is also central.
pass over. Why? Why should I grant it for the mere asking? Just because you have a bad case? On the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed before the next available circuit.
15.
Pass over.
16.
State. Pass over.
17.
I'm for the state lordship. এটা একটু দিন
De facto. Yes, Mr. Ganguly, no recovery.
Lordship, Cecil is কোথায়? Lordship, this was allotted to Nila Chakraborty. He is in court number 3. I'm
Take your time, take your time. See the Caesar list.
Still list কোথায়? Barcode? Sorry, দেখেছে। আচ্ছা। Caesar list. From the possession of Swapon Sarkar, Pinky Haldar, petitioner কে? Narayan Bormon. Swapon Sarkar and Pinky Haldar. ওর নামটা কি আসলো?
Commercial.
Commercial. 161 কোথায় page?
Issue. No money trail, no CDR, nothing.
No.
Uh,
But the application has been sent regarding CDR, but we could not collect this.
the petitioner says that there was no recovery of narcotics from him. Stop. He has been implicated solely on the basis of statement made by co-accused persons from whom seizure was made. Seizure of commercial quantity of narcotics was made. Stop. Charge sheet has been submitted upon completion of investigation. Stop.
I'm extremely sorry, Lordship. Bank statement requisition was given and they have submitted the statement that transaction is there. The car account? Or Bakaboroni account? Narayan account? Account of Narayan Burman.
This is account of Narayan
Narayan
Burman.
Burman.
Yes.
Okay, Uttam Das bail was rejected. Uttam Das and Narayan Burman same footing.
Bail was rejected or
Of
anti-bail?
Uttam.
Bail or anti-bail?
Bail. Lordship, the order has not been uploaded, but the status report is there.
Ki bollam?
Same footing. এই তো, Uttam Das.
Stop. His custodial interrogation is not necessary. Paragraph. While admitting that there was no recovery of narcotics from this petitioner, comma, learned State Council draws my attention to bank details of the petitioner, which shows his prima facie complicity in the alleged offense. Stop. I further see that another accused person by the name of Uttam Das, standing on substantially the same footing as this petitioner, was denied bail. Stop. Paragraph. In view of the prima facie involvement of the petitioner in the alleged crime, and keeping in mind the restrictions in section 37 of the NDPS Act, I am not inclined to entertain the petitioner's prayer for anticipatory bail.
Thank you.
I'm for the state.
Application are rejected at this stage. But nothing has been recovered from the petitioner. Can you see page 10 and 11? Page 11, paragraph 3 at this page. Subsequently, charge sheet and subsequent 12th of March 2025. But after filing of charge sheet, there is no evidential value of the point. Nothing has been recovered. What recovery was made from the margin.
Lordship, here the petitioner is Ibrahim Haq. Though he is named in the FIR and charge sheet, but in the Caesar list reflects that it has no contraband has been recovered from him.
Custodial intervention is necessary or not. I will finish the trial.
Yes, what is the material against him?
His name transpired in the FIR, also in the charge sheet, but nothing recovered.
In the
from
FIR on the basis of what? Co-accused statement.
co-accused.
What about Tufan Singh? Any money trail? Any
No money
CDR?
trail, no CDR, no money trail.
Then
No money trail, no CDR.
issue. The petitioner renews his prayer for anticipatory bail. Stop. He says that his prayer was earlier rejected on February 14, 2025, since investigation was in progress and charge sheet was yet to be filed. Stop. Charge sheet has been
Charge sheet
filed.
has been filed on 12th March 2025.
However, charge sheet has since been filed on March 12, 2025 upon completion of investigation. Stop. Paragraph, the petitioner says that there was no recovery of narcotics from him. Stop. His name has come in solely on the basis of statements made by co-accused persons. Stop. He prays for and he renews his prayer for anticipatory bail. Paragraph, learned state advocate says that the petitioner's name features in the FIR, first information report. Stop. However, he fairly admits that the implication of the petitioner is based on statements made by co-accused persons. Stop. Paragraph 2, my query as to whether or not there are call details report and oblique or money trail linking this petitioner to the alleged offense, learned counsel for the state fairly submits that no such material is available in the case diary. Paragraph, in view of the aforesaid, I am of the opinion that the petitioner has been able to tide over the restrictions in section 37 of the NDPS Act. Stop. Further, there is change of circumstance in as much as charge sheet has been filed upon completion of investigation since the last rejection of the petitioner's prayer. Now, hence, I am inclined to allow the petitioner's prayer.
Lordship, item number 21 day accommodation.
20.
20.
Who is for the petitioner?
1 day. 20.
Not today.
Oh, 21.
Chalo.
I am for the state report. Yes. Pasovan.
22.
My lord, I am applying for the petitioner.
I am applying for
My lord, the BNS, my lord, 680 and 85, which are the 304B and 498A of the Indian Penal Code. Now, my lord, the petitioners before your lordship is the father-in-law who is 75 years old, the mother-in-law who is 62 years old, and the sister-in-law who is Ja. Now, lordship, kindly see the FIR, my lord. There is no criminal overact or lordship the specific material against the father-in-law or mother-in-law. Whereas against those persons against whom the specific allegations are there, they have already granted anticipatory bail. I have annexed this document. They are the brother-in-law, elder brother-in-law, and the married sister-in-law and her husband. Since she is the married sister-in-law, therefore bail has been granted. Although my lord, specific allegations is there against the married sister-in-law. But whereas
Married sister-in-law lives somewhere else.
but there, in the FIR, there is specific allegations. When father-in-law, mother-in-law, my lord, no.
Yes, sir. What is there against these
My lord,
petitioners?
only one ground lies for objection, my lord. The principal accused still absconding.
Husband.
Otherwise, my lord, general allegation against all
General
the
allegation.
accused persons. But only one thing I have to say, principal accused still absconding.
Catch hold of him. These are aged people.
Yes, yes.
They will cooperate in whatever.
Yes.
Charge sheet pending.
Investigation pending, my lord.
The petitioner numbers 1 and 2. Now, the petitioners are the father-in-law, mother-in-law, and sister-in-law, respectively, of the victim lady. Stop. The charge is under the allegation, correct? Allegation is under sections 80, 85 and 62 of BNS 2023. Stop. Corresponding to sections 498 capital A and 304,
304B.
304B
And
capital
my
B
lord, 62 is 511.
and 511 IPC. Stop. Paragraph. The petitioners say that they have no role to play in the alleged offense. Stop. The prime accused is the husband of the victim lady who is at large. Stop. The petitioners say that the petitioners will cooperate fully with the investigating officer. Stop. They pray for pre-arrest bail. Paragraph. Opposing the prayer, learned State Counsel says that the husband of the petitioner, the prime accused, is absconding. Stop. He shows me the statements of witnesses recorded under section
161, my lord.
480.
180 to 180.
180, 180. 180. 161 is 180.
Yes, my lord. 161 is my lord, 180.
180 BNS. Stop. There are omnibus and general allegations against these petitioners. Stop. I also find that although another sister-in-law of the victim, being the victim's husband's sister, married sister, was named in the FIR, is named in the FIR, she has been granted bail, anticipatory bail. Paragraph on an overall assessment of the facts and circumstances of the case and the possible extent of complicity of these petitioners in the alleged offense. I am of the opinion that immediate custodial interrogation of these petitioners may not be necessary so long as they cooperate with the investigating officer. And also keeping in mind the advanced age of the petitioner numbers 1 and 2. That could you.
I'm great.
Yes.
দুজন মহিলা আছে ওদেরকে রিপোর্ট করতে বলুন
23.
For a short possible lordship. Lordship, item 24, just receive the case date, lordship, 1 day, lordship.
24 CD
24, just receive the case date tomorrow, lordship.
Great.
And 25 lordship, CD not produced. Okay.
not today, both not today.
May
please, the lordship, this is my application, lord.
State is not there. 26 who is for the state.
Short possible lordship.
27.
27 CD not there. Not today.
Following item number 28 and 29 in being for passable. 28 and 29 being for passable.
CD not produced.
Lordship, I am for tomorrow, lordship.
I am for the petition.
Pass over.
32.
My lord, 31, I am appearing for the first informant, my lord. The de facto complainant, my lord.
Passed over. Next 32.
32.
কেউ নেই
33.
Sir, not today.
Huh?
I'm paying for not today.
33.
Why not today, sir?
Going to hospital for his mother.
Senior is?
Hospital for father.
Oh, I see. Not today.
34.
But I'm on the petition.
34 state.
Short password.